Welcome back, everybody, to our next installment in our look at the Bill of Rights. The first thing we're going to do is we're going to review where we left off with our last couple amendments, the second, third, but most importantly, the fourth. The Second Amendment has to deal with the right to bear arms. If the government turns bad, the citizens should be able to revolt or protect themselves against a tyrannical government. The third prevents against illegal quartering of soldiers in their homes. These two are clear, direct calls to the American Revolution, issues that the colonists had living under British rule following the French and Indian War. To take this a little bit more relevant to issues we see even in modern day is most definitely going to be the Fourth Amendment. And the Fourth Amendment deals with search warrants. A search warrant is a legal document granted by a court that states the officials have reason to believe, they have evidence, not just reason to believe rather, but evidence to prove that an individual may have any evidence or criminal activity or paraphernalia that might indict them in a crime, and they have evidence of this. They have information that states where they believe this to be, what they are looking for, and is approved by a judge. This is the only time when an public official can go through and seize private property. It is a legal document allowing for the search and seizure of private property of citizens. But again, there are qualifications to get there. If information is obtained illegally, however, then it is inadmissible to court. It's called the exclusionary rule. Now, there are cases where police officials can search private property without a search warrant, and we looked at two cases in particular that deal with this. There's Florida versus Hardinez, which involves a drug-sniffing dog going up to the front porch, and Kentucky versus King. In both cases, the police officers obtained evidence or obtained information, perhaps rather than getting the search warrant prior. In Florida versus Hardinez, a search warrant was acquired, but it was acquired after a drug sniffing dog alerted to the smell of narcotics. And the use of that police dog, whose sole purpose is to sniff for narcotics, is considered as a search. So Hardinez's rights were violated, and all of that information was then thrown out. In Kentucky versus King, officers were chasing a suspect. He turned around a corner. They lost sight of him. They heard a door slam, and as they were searching for him, they came across the dwelling of Hollis King, a different individual. And as they knocked on the door, King didn't open up, but there was noise behind the door that indicated that some sort of illegal activity was happening, that something was being destroyed. And so the officers burst in the door, and they captured King in the act of attempting to destroy drug paraphernalia. Now, in King versus Kentucky, we saw a result that the officers were justified in that action because of clear and present danger. In Florida versus Hardinez, the officers created that incident by searching with the drug sniffing dog before obtaining the search warrant, which was an illegal search and seizure of property. In Kentucky versus King, there was imminent threat that they needed to act or that evidence would have been destroyed. So there are different circumstances in which these cases find themselves, and it's super important to not just look at the incident of did they have a search warrant or did they not. The context of the incident is super important in determining the legality of it all. So today we're going to take our focus and we're going to shift from the Fourth Amendment to the Fifth Amendment today, and we're going to take those skills, those concepts that we took in the previous videos, previous lessons, and we're going to continue to compound them and use them in these future cases. The Fifth Amendment to the Constitution says that no person shall be held to answer for a capital or otherwise infamous crime, which means known for a bad reason, a very serious crime, unless on a presentation of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. So all citizens, if they are going to face a serious crime, what's called a capital crime, the most severe crimes in a society, they must be given a trial by jury. A grand jury is a group of peers, fellow citizens that are pulled from the population in the area to decide on the fate of the course after hearing all of the information. The only exceptions we have right here are those for the naval forces or those in the militia. So any of the armed forces have their own separate court system, and it's called the martial court, but or being court-martialed rather. And so that's a totally separate issue. But for the general population, indictment by a grand jury, if you are going to be tried for something like murder that could face life in prison, extreme penalties, you must be judged not by one individual, but by a jury of your peers. Now, the Fifth Amendment continues. The Fifth Amendment is much longer than any of the previous amendments we've seen, and so we're going to go into the nuances a bit more. It continues, nor shall be compelled in any criminal case to be a witness against himself. This is known as self-incrimination. You cannot be forced to indict yourself, to incriminate yourself. This is what people say when they wish to not speak. They say, I plead the Fifth, which means I am pleading the Fifth Amendment, my right from freedom from self-incrimination, essentially that right to remain silent. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. This is a principle known as double jeopardy. What double jeopardy means is if you are taken to trial, right? Not just charged with a crime, but taken to trial for a crime in front of a jury of your peers, and you are found innocent, you cannot be brought back to trial for that same crime. What that means is if an individual commits a crime, say that John Smith decides to kill Karen Smith, then in that case, if they're taken to trial or if he's charged in that case and he is found innocent, right, by that jury of peers, then he cannot be taken back to trial for the murder of Karen Smith. He can, however, be taken to trial for a different murder. So in that case, you cannot be continuously retried on the same case once you are proven innocent. This is a callback to issues that were seen in society prior to the American Revolution, where some people were put in trial time and time again until sometimes they would break down to make that sort of torture stop. So if you are found innocent in a trial by jury, you cannot be taken back to court for that crime. Now, that is not to say if you are found innocent of a murder charge that you can commit murder at will. You just cannot be brought back to trial for the murder case in which you were found innocent, even if you admit to it after the fact, even if there is video that is discovered after the fact. Once you are found innocent by a trial by jury of your peers and you are acquitted of those charges, you cannot be put in jeopardy of going to jail or serious penalty for that crime twice. That is where the term double jeopardy comes into play. So what we're going to do, just to show you how that works, is a very odd principle to most people, and they don't really have a good understanding of it. We're going to go through the story of a man named Mel Ignatow. In 1988, Brenda Schaefer, who you see down at the bottom of the screen right here, went missing. Her ex-fiance, Mel Ignatow, right here, was the prime suspect. He was known to be abusive. He was very disliked by her friends and family. And to thicken the plot, Mel Ignatow's ex-girlfriend after Brenda Schaefer, Marianne Shore, who you see right here, came forward to police and claimed that she helped Mel kill Brenda and hid her body in the woods. The crime was super brutal that Marianne described. She described a story where Brenda was tied up to a glass coffee table, stabbed multiple times until she eventually died. Then that body was mutilated and taken into the woods to be buried. She also claimed that Mel asked her to take pictures of Brenda's dead body, to take pictures of the act. Shore's testimony brought a charge up against Mel, as they found Brenda's body in the woods exactly as she described. However, they needed more of a solid confession to connect the body to Mel in this court case. The police officers made Brenda wear a secret microphone to try to get Mel to admit to doing the crime and to speak about it, but she was unable to get him to admit it. And the pictures that Marianne mentioned were never found. Although the police didn't have a confession or physical evidence linking Mel to the crime, he was still charged with murder, brought before a judge, and the judge concluded that there was enough evidence to bring him to trial. So Mel was put on trial in front of a jury of his peers for the murder of Brenda Schaefer. His ex-girlfriend, Marianne Shore, gave her testimony, but the jury didn't believe her. The full story did not seem to link up without the other corroborating evidence, and so Mel was acquitted, which means he was found not guilty of the crime. Now, to make things more complicated, 6 months after Mel Ignatow was acquitted of this murder, he left the house. He tried to move away to try to get away from the town and the media frenzy, and residents of the house that he used to live in started to renovate it. As they went through and renovated the attic, they found things hidden under the carpet in the upper levels of the house. They found undeveloped rolls of film. They took the pictures in because they were curious to see what happened, and when the pictures were developed, they revealed the crime exactly the way that Marianne Shore, Mel's ex-girlfriend, had described it. However, due to the double jeopardy clause of the Fifth Amendment, Ignatow could not be tried for the murder of Brenda Schaefer. He was already found not guilty of that crime. Now, that does not mean that Ignatow could go and commit murder whenever he wants, but he was found innocent of that crime by a jury of his peers. Therefore, he could not be taken back to court for that crime. This is why the legal system, following the precedents and following the rules, is so very important. However, there were things that the lawyers tried to do once they figured this out to try to get Ignatow in jail. They pegged him for perjury, which is lying under oath, because they knew that he couldn't be retried for murder. He confessed in court at his perjury trial, but they couldn't take him to trial for that because he had already been found innocent. He turned to Brenda Schaefer's brother in court and said that he'd killed her and that she had died peacefully, and he didn't really seem really that remorseful. Ignatow served 5 years of an 8-year sentence for the perjury charge, which is lying under oath, and the state later prosecuted him on another perjury charge in court, and so he served another 9 years for that perjury charge, and then eventually he was let out. However, the irony of this entire situation, if there is any glimmer of hope from it, Ignatow dies in 2008, and as he was home alone, he slips and falls and hits his head on a glass coffee table. Things kind of became full circle here. But the moral of this story is making sure that the proper evidence is obtained in a legal way, and that there is a significant evidence to file and complete and win a court case is so important, so that people cannot be drugged through the mud for the same crime over and over and over and over again. Once you have been acquitted, right, you are able to kind of have your peace with this and not be continuously harassed for that crime. So the double jeopardy clause is meant to protect innocent people that have been acquitted. However, in this case, it kind of slips an evil man through the cracks. But our justice system is more concerned with protecting the innocent than convicting the guilty, right? That's why we are innocent until proven guilty rather than guilty until proven innocent in our justice system. And that's the way it was designed. There are flaws to it, like every single legal system, but in this case, although it is an unfortunate scenario, the way that this turned out, this has been used to protect innocent Americans from retrial time and time again. Now, we can continue with the Fifth Amendment. The Fifth Amendment extends even further. Nor can an individual be deprived of life, liberty, or property without due process of law. So the unalienable rights, right? Think all the way back to John Locke, right? Those Enlightenment ideas that the revolution was founded on. You cannot be deprived of life, liberty, or the pursuit of property unless you are given the due process of law. If you are a danger to society or you take away those rights from other people, then that is acceptable. But you must be given a trial, even if you commit a serious crime like murder, and there's a video of you doing it. You admit to doing it on camera, right? You post the video yourself, all of the evidence in the world against you, you still must be taken to trial. And if you are asked on the case, how do you plead to the charge, guilty or not guilty? If you say not guilty, despite all of this evidence around you, you are guaranteed the right to a trial. Now, it is going to be a very quick trial, for sure. It's not going to be a long one. It's not going to be a winnable trial for you. However, right, you are still awarded that trial. No matter what, no matter who you are in the United States, you are granted that right as a citizen. The Fifth Amendment still continues. Like I said, it's a long one. Nor shall private property be taken for public use without just compensation. This is called eminent domain. The government cannot come through and take your private property for private means. The only time your property can be taken from you is if, right, is if your property is going to be used for the greater public, and it must be used. It's not just that they want it, but they need it to happen. When I was growing up, my house, part of my yard, was taken by the local town government in order to straighten out a very, very dangerous road that curved around onto a bridge, and many people got into an accident. Some people flipped their car over the bridge or ran off onto the road and blew out tires. So the town government wanted to straighten out the bridge when it was a curved bridge. So in order to do that, they needed to make a straight line, but it had to cut through private property. It went through the yard, part of the yard of my home, and they needed to straighten out the road, and they took it for public use, and they had full right to do so. After it goes through kind of the town proceedings and the legal proceedings, once it was approved, that was the law of the land. Now, in order to take that land, they had to provide my family with compensation for that piece of land that they took. They can't just take it because they want it. If they are taking your property, you are entitled to compensation for that property if it's for public use. Now, when we talk about this right to fair trial, there are so many different nuances that we can look at. And one of probably the most important cases is a case called Miranda v. Arizona in 1966. So on March 13th, 1963, Ernesto Miranda was arrested in his house and brought to the police station where he was questioned by officers in connection with a kidnapping and rape. He was interrogated for 2 hours. The officers told Miranda that the girl that you kidnapped has already identified you. And Miranda said, was kind of thinking to himself, well, I mean, I guess that they've already got me, that I'll have to, I'm kind of dead to rights. Like I don't have a prayer here, so maybe I can sort of get maybe a deal. I'll just confess to it and make this easier, and maybe they'll go easy on me. He doesn't fully read a confession. He signs the piece of paper that the officers give to him, and he confesses to this crime. Now, the written confession was used in court, despite the fact that the officers admitted that they didn't ever advise Mr. Miranda that he had any right to an attorney during that 2-hour interrogation, and the jury found him guilty. They did not accept the claim that his Fifth Amendment rights were violated because he never actually asked for the right for an attorney or the right for counsel. However, Miranda appealed his conviction. He claimed that he was never told of his Fifth Amendment rights to prevent from self-incrimination and the right to an attorney. Therefore, that interrogation and that information was obtained illegally. And we know, based on our discussion on the illegal searches and seizures from the Fourth Amendment, that if evidence is obtained illegally, it must be thrown out of court. So the question at hand is, were Miranda's Fifth Amendment rights violated by the officer's interrogation, not telling him of his right to an attorney or freedom from self-incrimination? Or was it Miranda's responsibility to ask for that counsel? They never denied him of the right, according to the officers, but he just never asked for it, so that they didn't give him something that he didn't ask for. So who should win this case, Miranda or Arizona? I'll give you a second to decide now. Pause the video if you need to, and then in a couple seconds, we'll switch to the next page. In this court case, in a 5-4 decision, the closest possible ruling in a Supreme Court decision, the Supreme Court rules in favor of Miranda, stating that suspects must be read their rights before they can be interrogated. They must be informed of their Fifth Amendment rights. If they are not, right, then all of this information is thus obtained illegally and then thrown out. So Miranda's confession is thrown out of court and inadmissible in court. These readings of these rights are known as the Miranda rights, and some of you have likely heard of them today. It comes from this court case. Again, this is a really close court case, so it's super important to understand the gravity of the scenario. Now, if the Miranda rights are not read to suspects before any form of interrogation begins, that information is obtained illegally. It's like searching private property with no reason, without a valid search warrant. That information is thus illegal and must be thrown out. Some of you may have heard the Miranda rights. Some of you may know them, or you may know the first line. You have the right to remain silent. Anything you can, and anything you say can and will be used against you in the court of law. You have the right to an attorney, which means a lawyer. If you cannot afford an attorney, one will be appointed to you. And after these have been read, these 4 points have been read, knowing and understanding your rights as I have explained them to you, are you willing to answer my questions without an attorney present? If they say no, the officers must wait until the individual has the opportunity to call an attorney and that attorney arrives, and at that point, then they may interrogate. If they say yes, then they can interrogate away, and that is a voluntary waiving of those rights. Now, some of you may have seen the movie 21 Jump Street. At the very beginning, Channing Tatum's character tackles a suspect, and he elicits this interrogation that this person's been selling drugs, and the chief of police asks him, did you read him his Miranda rights? It's like the one thing that you have to do. They failed to read him his Miranda rights, and as a result, they had to let him go. He didn't really know it. He tried to lie on the spot, and as a result, that suspect went off free, even though they were completely guilty. You must follow the law, so it is very difficult to be a lawyer. It is very difficult to be an officer if you want to follow the legality protocols. If this step is skipped and interrogation occurs, all of the information obtained from that interrogation must be thrown out. So, again, right, statements that verbal confession is the equivalent to finding a tangible object. And so we really have to make sure we understand how these amendments fit together, the rights of the individual, and how the Supreme Court looks at these. These can completely overturn court cases. So it doesn't matter that the information is there. The information was obtained illegally. As I said earlier, this country is more concerned about protecting the innocent than it is about convicting the guilty. This takes us to our next court case, Rhode Island v. Innis from 1980. So a man named Thomas Innis was suspected from robbing and murdering a cab driver in Providence, Rhode Island with a sawed-off shotgun. The police arrested him and read him his Miranda rights twice before he was put into the police car and taken to the station. When Innis was arrested, he was unarmed. They didn't have the firearm. They didn't have the weapon, the key piece of evidence in this court case. As they were taking him from the place that they picked him up to the station, the officers were having a conversation with each other about the failure to recover that weapon. One of them mentioned that the arrest took place near a school for handicapped children and that they would hate to see any child accidentally pick it up, think it was a toy, hurting themselves if they found it. After Innis heard the conversation in front of him, he started to have a change of heart, and he interjected and told the officers where the gun was after his rights were being read for a third time. They recovered the weapon. They held him without bail until the court date. He went to trial in Providence, and he was convicted. However, feeling his Fifth Amendment rights were violated, he and his lawyer appealed to the Rhode Island Supreme Court and won based on the argument that the conversation coerced him into giving a forced confession that he did not want to give. The prosecuting lawyers for the state then took this case all the way up to the Supreme Court and appealed on this ruling. The major question we have to decide is, did the police officer's interrogation on the way back to the station violate Innis's Miranda rights? So take some time to figure out your decision. Pause the video if you need to now. Think about, is this a violation of any of the rights spelled out in the Fifth Amendment? The ruling of the Supreme Court was no, Innis's rights were not violated, so the appeal was then overturned again and Innis was sentenced. This was a 6-3 decision, so it wasn't the closest possible decision we could have gotten, but it was still a very close one. The rationale was that the officer's conversation didn't qualify as an interrogation. And even if it had, there wasn't any law from you deciding to incriminate yourself. You have the right to remain silent to prevent you from having to do so. And Innis could have remained silent. He was read his Miranda rights twice before that happened. And then after that, he confessed. They read his Miranda rights a third time, and then he confirmed and corroborated that story, showing him where it was. There would have to be clear, explicit evidence that the police officers were trying to have this conversation, try to like play the pity card, and to force him into confession, and that evidence just plainly didn't exist. There was no way of proving that unless the officers admitted to it. So the Supreme Court ruled that the officers were simply concerned with the children in the area, and there was no way that there was an expected confession from Innis as a result of this conversation. Therefore, he went back to a guilty verdict and had to serve his sentence. So again, context. What constitutes as a search, right? What doesn't? Were the Miranda rights read? Were they not? And what that implication means for the future is very, very important. Now we'll move on to a case later in the 1980s called New York v. Quarles. And in this court case, police officers in New York City were called to a grocery store after a alleged rape suspect, Benjamin Quarles, was sighted going into that grocery store and being armed by the woman he allegedly assaulted. After receiving the description of Quarles from the woman, one of the police officers entered the supermarket and actually spotted him and ordered him to stop. Quarles, however, just started to run out of the back door, and the officer lost sight of him for a couple seconds. However, after the officer exited the door, he was able to capture Quarles immediately. After Quarles was apprehended, he was searched and frisked for a firearm. They could not find anything on him except for an empty holster for a gun. The officer asked Quarles where the gun was. Quarles pointed over to a location, and at that time, the officer formally arrested Quarles and then read him his Miranda rights. After he was arrested, Quarles continued to answer questions repeatedly and stated that he did not want or need an attorney for the questioning. Later, however, he received a lawyer for the future court proceedings that followed. But due to the fact that Quarles was questioned about the location of the gun prior to him being read his Miranda rights, Quarles' lawyer stated that the Fifth Amendment rights were being violated at that point, and therefore he demanded that all of those testimonies that followed be thrown out of court. So the question is, was there a violation of Quarles' Fifth Amendment rights by the officers by asking for that location of the gun prior to his Miranda rights being read? Now, we know the implications of what that means if that is ruled in Quarles' favor, but the question is what constitutes as a search in the Fourth Amendment, but also what constitutes as a interrogation under the Fifth Amendment. So what do you decide? The Supreme Court is going to rule in favor of New York in a 5-4 decision. Super, super close. Now, they have two basic pieces of rationale about why they believe so. Number one, that there is a public safety exception to officers issuing the Miranda rights to suspects. If there is a imminent danger or a possible danger to the public, that they can circumvent the Miranda rights prior to capturing and interrogating the individual if lives are at risk, if public safety is at risk. Number two, also, because the police officer's request for the location of gun was needed to assure that an innocent citizen was not injured or that it didn't fall into the hands of an accomplice to Quarles, the officers did not need to read the Miranda rights to Quarles. Thus, his constitutional rights were not violated. So again, the context, it's kind of like the clear and present danger rule in the Kentucky v. King case, where the officers were able to enter that dwelling without the warrant. And in this case, they were able to commit that search in order to protect, right, from a potential crime being committed or for the safety of the surrounding public. Our last case today is going to be called Dickerson v. U.S., and this is really about the larger scope of why laws are put in the way that they are and the power of the federal government in relationship to each other. There was an individual, Charles Dickerson, who was being questioned about a robbery that he was connected to by the FBI. And in that questioning, he admitted to being the getaway driver for multiple bank robberies. At that point, Dickerson was put under arrest, but the problem is the timing of when he gave his statement is heavily, heavily disputed. The FBI and all the local authorities testify and said that Dickerson was advised of his Miranda rights that we talked about in Miranda v. Arizona and waived them before he made his statement. Dickerson, however, says that he was not read his Miranda rights until after he gave his statement. The problem is that after he is convicted of this bank robbery with this interrogation, Dickerson requested that his statement be thrown out because he said that he had not received his Miranda rights before being interrogated. If that was the case, then what would happen is that evidence would be excluded from court according to the exclusionary rule. The government, however, argued that even if the Miranda rights were not read, that the statement was given up by him voluntary. It was not a forced confession or forced interrogation, that he voluntarily gave the information up. Therefore, if it is voluntarily given up, there is no need for those rights that he had foregone and circumvented essentially his own rights by doing so. He had forfeited them and thrown them aside. There was also a federal law that says a confession is admissible in evidence if it is given voluntarily. The Miranda rights are then irrelevant if right, they are given voluntarily. The district court threw out Dickerson's testimony because he had not been read his Miranda rights or signed a waiver until after he made a statement. However, the court didn't really address the federal law that the government used to argue, saying that the Miranda rights could be circumvented if it was given voluntarily. However, despite this, it was sent up to an appeals court, and the court acknowledged that Dickerson had not received his Miranda rights, but that the federal law allowed it to be used as evidence because the statement was considered voluntary. The court said that Congress created this law with the sole purpose of legislatively overruling Miranda and restored voluntariness as the test for kind of admitting confessions in a federal court. In simple terms, that means that Congress created a law that said if individuals voluntarily give up information, that can still be used as evidence in court regardless of the Miranda rights because they threw away essentially their Miranda rights. The real question we have here is this law, Congressional Law 351, that allows for the overruling of the Miranda rights if it's given in a voluntary confession. Does Congress have the power to do that? So the Supreme Court will take this ruling all the way up to their court, and they will have to rule on, number one, were Dickerson's rights violated, right, or not? And the crux of that centers around this law. So if the Supreme Court rules in favor of the United States, the law stays in effect. Dickerson is then convicted. However, if the Supreme Court rules against the United States, they would have to rule that Federal Law 3501 is illegally, right, violating the constitutional rights of citizens and thus mark it unconstitutional and null and void. So who should win this case? Does Congress have the ability even to circumvent the Miranda rights and pass this law to trump that Supreme Court decision? Make your decision now. The Supreme Court rules 7-2 in favor of Dickerson, and the rationale is nothing can override a Supreme Court ruling. The Miranda rights are routine in police practice, and that is still true to this day. It upholds the supremacy of the Supreme Court in legal matters, so it upholds the strength of the judicial branch. As a result, Dickerson's confession is thrown out, his conviction is vacated, but the problem is, for some people, is what did those other two judges argue? The other two judges basically said that the other 7 judges kind of gave needless protection to fools, right? That when people do that, it's stupid, but they idiotically vacate their right. And so you really have to think about where you would fall in this issue. However, regardless of your initial reaction to it, the only way that this sort of decision could be overruled would be in a future Supreme Court ruling. And that's the way our government is set up, to allow for these precedents to stand, to allow for kind of this black and white nature when it comes to law as much as possible, to allow for some consistency in conviction. Now, today we spent a lot of time solely focusing on the Fifth Amendment. We looked at the idea of double jeopardy. We talked about just compensation for property called eminent domain. We talked about protection against self-incrimination, the right to a grand jury, and the general right to due process of law. Now, there's a lot of things crammed in the Fifth Amendment, which is why we gave it its own day, its own video. However, if you have any questions, which is totally normal, feel free to drop a comment down in the section below, and I will get right back to you as soon as I can. Take care.